I'm sorry?
Randy Wood.
All right, thank you, sir. You're here for a 215 case?
Yeah.
All right, we'll be with you in just a minute. Good afternoon, everyone. I'm going to call the 2 o'clock docket. When I call the docket, if you're associated with that, please unmute yourself, and then I'll ask for you to identify yourself when time comes. The first case I'm calling is Synchrony Bank versus Kristen Alexander, file 20-08165GC. Would the attorney for the plaintiff please identify himself?
Good afternoon, Your Honor. David Canine, last name spelled C-A-N-I-N-E, P61828 on behalf of the plaintiff. Thank you.
Thank you. Do we have Ms. Alexander here? It looks like we do. Good afternoon.
Hello,
Please state your name for the record.
Kristen Alexander.
All right. A while ago, we were doing a pre-trial, and I was pontificating out when the days were going to be warmer, and we were going to come back and ask how this case is coming along, and here we are. So, Mr. Canine, have we reached an agreement in this case, to your knowledge?
Yes, we have settled the case. I'm not sure if Ms. Alexander's received our consent judgment yet, though.
Okay. Ms. Alexander, have you received it yet?
I have not gotten anything in the mail, sir.
All right. So, Mr. Canine, since we're both recording and broadcasting on YouTube, I could put the two of you in a breakout room. Potentially, you could send an attached copy by email. Then Ms. Alexander could print it herself and then eliminate one of the sources, or she could email it back to you. I know that we could receive that document back from the two of you. I'll give you our email address when it's completed.
Okay, that would be fantastic. Oh,
yeah,
sorry.
7. Yep. Ours is 75civil@co.midland.mi.us.
Okay, thank you.
All right, thank you. We'll be adjourned on this case. So I participate in the documents being signed. So, Ms. Alexander, even though the agreement's been reached, courts work with orders. And so unless I sign that order, the case is still active. If we don't get it within a period of time, I'll reschedule this for a status conference to figure out what's going on. So I think Mr. Canine and you will join a breakout room. Once you're done with the breakout room where you exchange emails, then you can just leave.
Okay.
Okay?
Okay, thank you, Your Honor. Your Honor, I do have another one before you, the Crown asset file, but if it's okay, I'll speak with Ms. Alexander and then come back.
Why don't I just call that one quickly?
Okay.
And then I'll send Miss Alexander into a breakout room. If you would wait there for just a moment, you'll be by yourself, and then he'll join you in just a moment, okay?
Okay, thank you.
Thank you, Your Honor.
Thank you. All right, calling case of Crown Asset Management versus Monica Wolfgang. This is file 21-08859GC. Counsel, please identify yourself for the record.
Again, David Canine for plaintiff, last name spelled C-A-N-I-N-E, P61828. Thank you.
All right. And Ms. Wolfgang, if you would please identify yourself.
Monica Wolfgang.
Okay, today's time and date set for a pre-trial. Ms. Wolfgang, you're representing yourself. Is that correct?
Yes.
All right. What I'm going to do is set this for a date in October 6th at 2 o'clock, where we're going to come back on a settlement conference. It will look and feel very similar to today's date, but that's going to allow enough time for you to work with Mr. Canine and see if you can reach an agreement. If you cannot, on October 6th, I'll ask you if you've got it resolved or not. And if you don't, then I'll hear the case and make a decision, whether it's by a trial or by motion. So there is an order that I'll be sending out that'll give you some dates, very specific dates. Again, the next time you'll be in court is October 6th at 2 o'clock in the afternoon. So you want to have a chat with Mr. Canine or to try to resolve the case. If not, then I will make a decision whether it's at a hearing or whether it's a motion for summary disposition or at a trial. Do you have any questions?
No, not if I can talk to him. What happened is I went with a debt settlement company, and they did several offers to settle the debt. They offered like 10 times, and the last time they offered, they accepted the offer, but then the next day it went to, someone sent it to the lawyer. So
why don't we do this? I'm going to put you in a different breakout room, and when my staff sees Mr. Canine's by himself, then we'll put the two of you together and get a chance to chat. So if you could just hang out in the breakout room by yourself. Mr. Canine, once he's finished with the first person, will come talk to you.
Okay, thank you very much,
All right.
sir.
Thank you, Your Honor.
Thank you. We'll be adjourned. Just going to sign those real quick.
Miss Wolfgang, you do just have to hit join.
Didn't mean to get all fancy on you there, Katrina. I just figured that you could handle multiple breakout rooms.
Oh, you bet, sir.
All right. Next case is the case of Beaudry Trenching Incorporated versus Canaan Communications. This is file 21-08816GC. If the attorneys could identify themselves for the record, please. Mr. Brissett, we'll have you unmute yourself and then identify yourself. There we go. No, can't hear you yet. Did you join with audio?
I did.
There you go. I can hear you now. Please identify yourself for the record.
Mark Brissett for the plaintiff.
And do we have someone here for Mr. Bond? We have an attorney for Canaan
Oh,
Communications.
sorry, Your Honor, that's my associate. I'm Edward Plato, appearing on behalf of the defendant, Canaan Communications.
All right. Since I have attorneys on both sides of the aisle, I don't have to explain to you how the pretrial process works. You both have probably been in practice longer than I have. So our next settlement date is October the 6th. Amending pleadings will be allowed up to 14 days. Exchange of witnesses within 30 days. I do not order discovery. If the two of you agree to do discovery, you may do that. However, don't do as a lot of them been doing, agree to do discovery, and then all of a sudden I'm ending up with a lot of motions to compel. So if you plan on doing discovery, it's between the two of you to submit a stipulated order. I will leave motions for summary disposition open for 120 days. And I would like trial briefs 3 days prior if it goes to trial. Our next date for status conference is going to be by Zoom on October 6th at 2 o'clock.
Judge, I already know I'd like discovery.
I'm sorry?
Judge, it's Mark Brissett. I already know I'd like discovery.
Well, it would have to be agreed upon because it's not going to be ordered by the court because of the new court rule. So if there's a stipulated order, I will order it. I'm not going to unless it's stipulated by the parties. So we will adjourn until October 6th unless there's anything, Mr. Plato, you would like to place on the record.
I don't believe so, Honor. So will you be sending out an order with those dates?
I have the case scheduling order signed and ready to go.
Sounds good. I appreciate it.
Plato, Mr. Brissett, we can put you in a breakout room if you want to chat today just to see if you can agree upon discovery or not, or have some discussions, or you don't have to, but we do have the technology to put you in a private breakout room where you can just leave at any time.
No, that's okay, Judge. I can call Mr. Plato.
Okay,
Yeah,
we're all set then.
All right.
Thank you.
Okay, thanks, Judge. Have a good
Thank you,
day.
Your Honor.
Next case is Steve Scott versus Alan and Kristen Hartman. This is file 21-09161GC. If we could have Mr. Scott unmute himself and the Hartmans unmute themselves if they're here. I see Alan Hartman's by telephone. So Mr. Scott, since you are the person that filed the lawsuit, if you would please identify yourself.
Stephen Scott.
And Mr. Hartman, if you would identify yourself.
Alan Hartman.
Mr. Hartman, is Kristen Hartman with you?
No.
Okay. Do you anticipate her being here today?
No.
Okay. This is a pre-trial. I'll ask because I don't know for sure. Mr. Scott, are you an attorney?
No, I'm not.
Mr. Hartman, are you an attorney?
No, Your Honor. My attorney that I had scheduled retired. I just found out last week.
Or you're planning on hiring one?
I had one on retainer, but he retired. So we can proceed without a lawyer.
So I'm going to take just a minute to kind of explain the process. When people are not familiar with it, it'd be like me trying to go into some construction site and figure out what the heck to do. So I usually try to use what you do for a living and then beg your forgiveness because I don't always know what you do, but I'll take my best shot and make a correlation. Mr. Scott, what is it that you do for a living, sir?
I own a retail shop. It's a wellness store.
Okay, I could work with that. Mr. Hartman, what do you do?
I've retired actually several times, but I still actively work as a cybersecurity manager for the electric utility grid, protecting the electric grid.
All right. Well, I'll see what I can do with that one. That sounds kind of high tech for me, but I'll give it my best shot. So, Mr. Scott has filed a lawsuit against Mr. Hartman and Miss Hartman, and my job is to see the case to completion. I'm to kind of act a little bit like a referee. I'm not on one side or the other. I got to call balls and strikes, and ultimately I make the decision on the case. So, Mr. Scott, I'm going to use a sports analogy first, is that because you're the plaintiff and you filed the lawsuit, you have to win a little bit more than Mr. Hartman does. The legal term for that is preponderance of the evidence. So that just means you would have to provide proof 51% to 49% that what you're saying is true. A tie, just like in baseball, goes to the runner. A tie would go to the Hartmans. So if you don't convince me that your way is a little more true than not, if I think it's a jump ball, then the Hartmans win. Now, Alan Hartman's here. Kristen is not. So if Kristen got sued and she didn't put forward anything, she would lose automatically because she's not agreed to participate in the proceedings. So I don't know if she's planning on participating or not. So her case may be different than Mr. Hartman's. In other words, Ms. Hartman could lose automatically and Mr. Hartman could continue to fight another day. That's to be set, to be determined yet, not set yet. So how lawsuits work is that we get thousands of these. So most of them, I don't decide. The parties make an agreement. There's 3 ways this case goes away. So I want to talk to Mr. Hartman a minute. Mr. Hartman, there's 3 ways this case goes away. First way the case goes away is if Mr. Scott says, you know, I just am done. I don't want to play anymore. I'm going to dismiss the case. That's probably not likely because it made it this far, but I always check. Mr. Scott, are you planning on just dismissing the case at this time?
No, sir.
Okay. So, Mr. Hartman, there's 2 more ways the case can go away. The second way a case goes away is that if I decide this case or if you have an agreement. So most cases get agreements. Most people don't disagree on every single thing and they come to some resolution. So I allow some time for that. I'm going to allow about 3 months. So the next time we're going to come to court is on October 6th. And I'm going to ask you if you've had an opportunity to try to figure out the case on your own. If you don't, and that's fine because I get paid to make a decision, I can decide the case. And I can decide the case one of 2 ways. I can decide the case by a trial, which most people think of. They think of witnesses coming and exhibits being marked and me making the decisions on the case. Or I can decide the case on what's called a motion for summary disposition. So just like your work, Mr. Hartman, in the cybersecurity world, you have all of these phrases and terms that in 10 seconds, you could have me turning in a corner and scratching my head and figuring out what the heck you're talking about. I could do that too. But what I'm going to tell you is judges make decisions only if they're asked. How you ask a judge to make a decision is by motion. That's what it's called. I didn't name it. That's what it's called. So either side, Mr. Scott could do this, or you could do this, or Kristen could do this if she gets in the game, meaning she has to file an answer. You can motion me for a summary disposition. Summary meaning quick, disposition meaning ending. Either one of you could look at the court rules, and it's in court rule 2.116, and it outlines different kinds of motions. So Mr. Scott could say, you know what, Judge? I don't think Mr. Hartman even disagrees with me that he owes the money. That typically people sue for money. So let's just say that he did. I haven't looked at the complaint. He isn't saying that he doesn't owe it. He just says he can't pay it. So I should at least just win because there's no disagreement that the product was purchased or the service was done or whatever. He just doesn't have the money to pay. And those are 2 different animals. And so I would look at it and say, by papers, Mr. Hartman doesn't disagree. He thinks that he owes the money. He just doesn't have a pot to pee in or a window to throw it out of, and he can't pay it. Well, those are two different things, whether the money's owed or whether it can be paid. And so I could grant then Mr. Scott a motion for summary disposition. Or Mr. Hartman, you could say, look, I don't know the relationship between you and Kristen. Were you married or are you married, or is that some relation to you? Mr. Hartman?
Yes, Kristen and I are married. However, I'm a legal representative for any legal matters with the corporation.
Okay. Well, that's a different animal, because if there's a corporation, then that corporation would have had to been sued. Looks like Mr. Scott may have sued you individually as opposed to the corporation. So let's just say yep. So
I was
let
just
me
going
use
to say, Your Honor, that the lease is between corporations.
Okay, so if the lease is between corporations, neither of you can represent each other. So if there, I would have to take a look at the document and see how the lease was done. But that's a decision. So let me use that example, Mr. Hartman. And again, Mr. Scott, I've not looked at the pleadings for the case yet. It's a little early in the case. But let's say, for example, that you have, Mr. Scott has a lease agreement. And let's say, for my example, that Alan has a twin brother named Dale. And you signed the documents with Dale and not Alan. And Alan's like, I don't even know who this Steve Scott is. This Dale is my brother, and he obviously is my twin, so he knows my date of birth. He knows my names. He signed these forms. And Dale comes in and says, lo and behold, yes, it's right. I can't get credit in my own name. I signed Alan's name, and therefore I'm the person responsible. Well, if Alan had those proofs that his dastardly brother Dale, and if I actually guessed that you had a brother Dale, Mr. Hartman, that's totally luck and conjecture. But that would be something you could file a motion for summary disposition for, saying, I'm not the right person. He should have sued Dale. And then I could look at the paperwork, because if it's a lease, I will look at the four corners of the document, and then I'll make the decision. So that wouldn't have to wait till trial. That could be done by motion for summary disposition. And those, again, those motions, there's certain kinds. It's outlined in Court Rule 2.116C. And then there's all these 9 or 10 different kinds of motions. So again, recapping before we end today, 3 ways the case goes away. Mr. Scott dismisses the case. He says that's not in the plans. Second way is you guys come to an agreement, meaning the 2 parties come to an agreement. Or third, I decide the case, and I can decide the case either by trial or by motion. Now, I do allow enough time for people to try to get things figured out. And that the next time we're going to come to court, unless you schedule a motion for summary disposition, will be on October 6th at 2:00 in the afternoon. Also by Zoom, because I think it's pretty helpful and handy. Any trials will be in person, because trials are just too hard for me to figure out documents and figure out issues. Anyone have any questions regarding the timing? I'm going to send you to you a copy of this order. Mr. Hartman, any questions?
Yeah, just a quick. I sent my response letter back to the court on May 24th, responding to the allegation. And I also, in that letter, requested a dismissal, summary judgment based upon no evidence being presented. And I also provided a copy of the legal notarized contract that both parties agreed to. Okay.
You would have to schedule that for a motion for summary disposition. So you'd call my clerk's office and schedule a hearing date. So sending the notice in, asking for it, you still have to schedule it, but I will still send this notification. Sometimes people just pick the same dates that we already have set for them, October 6th, but it could be done before then. So at this point in time, we're going to be adjourned. I'm going to send notices to each party outlining the next dates in court and outlining the timing and information. Mr. Scott, do you have any questions?
No, I do not, sir.
All right, Mr. Hartman, we're all set then for today. Mr. Scott, we're all set for today. You can just leave the Zoom meeting. Thank you.
All right, thank you, Your Honor.
I see Ms. Wolfgang back, and I see Mr. Canine back, which tells me that maybe they've got an agreement they want to place on the record, or maybe they're just interested in the rest of the hearing. So let me recall that case. This is recalling the case of, pull it here. I'm going to get the right case. Here we go. Crown Asset versus Monica Wolfgang. So, Mr. Canine, welcome back.
Thank you, Your Honor. And I apologize. I think maybe I misunderstood the court. We are very close to resolution, but not quite there. And I know the
Okay.
subsequent date of October 6th. So I'm really we're checking back in just to make sure we're okay. Thank you.
Oh, yes, you're both okay to leave. October 6th, if you have anything. So, Ms. Wolfgang, here's how this works. It's bad English, but good law. An order's an order till it ain't. So I'm telling you to be here October 6th, but if you and Mr. Canine get it resolved before then, you don't have to go, but something has to have my signature on there saying don't come, because if you don't come and there's no order ending the case, whether it's a judgment or a dismissal or whatever, then you lose automatically what's called by default. Okay?
Okay, I
So you have to
understand.
be here on October 6th unless there's another document with my signature that says that the case is done.
Okay, thank you.
All right? Thank you.
Yep.
We exchange contact information too. Thank you, Your Honor.
Great. Thank you, Mr. Canine. Thank you, Ms. Wolfgang. We're all set.
Thank you, Your Honor.
Your Honor, do we need to go back on the record for Synchrony versus Alexander, or are we good on that one?
Unless you have something else, it's just a status conference. So you thought, do you have that one resolved? You thought
More or
you
less.
did, just in,
Miss Alexander a proposed consent judgment and some statements at her request. And she was going to call me in a day or so. It's resolved. So
after a couple of weeks, if we don't get something in a couple of weeks, we'll just reset it for another status conference.
fantastic. Thank you, Your Honor.
All right,
Take care.
thank you. You too. We're all set. We're all set, Ms. Wolfgang. You're all set to go.
Thank you very much, sir.
Thank you. Michaela, do we have anyone here on behalf of Progressive? I see Mr. Cisco's here.
Your Honor, I do not show anybody.
That's really strange. I'll call that in just a minute. I do have Mr. Woods who's here. Mr. Woods, why don't you come on up to one of the green chairs? Is there anyone in, Katrina, is there anyone in the virtual waiting room?
No, Your Honor.
Okay. I'm going to call first. Mr. Cisco, we'll get to your case in just one moment. I have one more just ahead of you, and then we'll call your case, all right? Calling case of Randall Woods versus K&J Transmission, file 21-40409SC. Good afternoon, sir. Please state your name for the record.
Randy Woods.
All right, today's time and day set for
Your
a
Honor,
show
I'm
cause.
sorry, I could not hear his voice.
Oh, could you say your name again, please?
Oh, I'm sorry. Randy Woods.
Was that better, Katrina?
Yes, Your Honor.
All right, today's date and time set for a show cause. I presume that the K&J Transmission has not met its obligation. Is that true?
True.
Did you get a money judgment then against him? How much was it for?
Well, the initial one, the initial judgment was $2,250, but then there's been some court costs and processing fees, and
How much do those total?
that'd be another $80.
And have you received any payments?
Nothing.
Okay. Michaela, have you received any paperwork whatsoever from K&J Transmission?
No, Your Honor, we have not. And the motion to show cause was actually personally served as well back on May 21st.
Okay. Is there any additional cost that you can see other than the $80?
I believe he's been doing pretty good at keeping track. Every time he comes, he's writing it down. So I believe he's in the ballpark.
All right. Then do we have an individual other than just K&J Transmission, or did you just sue K&J Transmissions?
It's husband and wife, James and Krista Prather.
Okay. Well, I will issue a bench warrant for failing to appear to K&J Transmission. The tricky part is that you sued their business as opposed to them individually.
Well, I know James Prather was served.
Yes, but let me see if I can put this in terms that may make more sense. Let me ask you, what do you do for a living?
I work in surveillance at the casino.
Okay. So you watching the tables and make sure everybody's doing what they're supposed to, or more likely not doing things they're supposed to?
Tables and pretty much everything else, yeah.
Your eyes are always watching, trying to see
Yeah.
what's going on. Okay. So in this case, you filed the lawsuit against the company, which is a perfectly fine thing to do. Even though individuals own it, you didn't sue them individually. You could have sued James, or you say her name was Kristen?
Krista, yeah.
Krista. So I can issue a bench warrant, but the bench warrant for arrest is against the company, and I can't put a company in jail.
Well, at the very first Zoom meeting, it was myself and James. And that's who I thought I was dealing with. And
Yes.
and then when I had him served, I had James.
Right.
served.
So I understand what you're saying. It would be like a person at the casino and new card deck gets in, brand new dealer, doesn't know what they're doing, and they leave the jokers in.
Yeah.
And they get a joker turned up, and the person thinks in their own mind that a joker is worth jackpot. Well, joker is just a card that doesn't have any value. And the person really thinks that that's the case, but the casino rules would say it was a mistake. You get the next card in the deck, but we're not going to give you the joker because he looks fancy that you win. So in this case, you sued and won against K&J Transmission, which is fine because you sued the company, but you didn't sue the person, you sued the company. So I can order an arrest or a bench warrant for a person, but I can't for a company.
I thought I did sue James. I think I'd have
Well,
to.
serving somebody and suing them are different. So Michaela, can you check the records to see who the defendants were listed?
So unfortunately, I did look it up, and that is a question that we ask when people file. And when I looked up his affidavit and claim, he originally had them wrote down, but he X'd them out and then just put the business itself, because people get confused when they come up and we ask, well, are you serving the owners as well, or just the business? And either some people will sue, the owners and the business, but in this case, he actually did X out the names and then wrote the business underneath.
Let me see if I can give you a different analogy so you can understand. I'm willing to grant you relief because obviously the person should be here, right? Let's say it's not a transmission shop. Let's say it's an accounting firm. And James Prather is an accountant, but he's an accountant at Yo, which is a company. He doesn't own the company. He works at the company, but let's say that he just really screwed up your taxes and you sued Yo because he worked for them, but you didn't sue him individually. Well, if you win, and it sounds like you did, I can tell Yo they need to show up, but how do I go get an accounting firm to put them in jail because it's a firm?
Can I sue them all over again?
You can decide to try to modify your complaint to add someone, but right now I can't put a transmission shop in jail. There's other ways that you could collect. If you knew their bank accounts, you could.
I filed for discovery and that, but nobody ever showed up for that.
Right. And so what I think we'll do, was there an answer filed in this, Michaela?
No, Your Honor, this was small claims, and then he did get his judgment by consent back in March, and then that is when he had his discovery set and they failed to appear, so that is why we're here today.
Was there an order ordering James Prather on the document? I don't have the document pulled up. Was there an order James Prather to appear at discovery?
No, Your Honor, it is just under the business's name because that's the only defendant that's listed.
Well, you could also, I have to be careful because I can't coach you. It'd be like a referee going into the offensive huddle and saying, here's how you're going to beat the defense, right?
Yeah, but I did write down their names on my paperwork.
Yeah, but then you scratched it out.
No, it's not scratched out. This is
Why
my
don't you bring it to
On
me
the-
to see?
So on the subpoena, he has their name
Okay,
for
So-
the so that would be for the discovery.
so their names were listed on the discovery and they were ordered, stamped to appear for discovery.
For discovery, correct, but not for the
Okay, so
motion for show cause.
Yeah, Mr. Woods, can you see the document? So
Yeah, I see it. I have it.
you crossed that out. So can you show me the discovery document then, or please? That's right, she's gonna show me here. on the
Oh,
computer screen.
One moment,
That's
Your
one of the
Honor.
advantages of having a computer pull up. Yes, Katrina?
I said, one moment, sir. I'm getting that for you.
Oh, you're pulling it up? I thought Michaela was using some
No, I pulled that one up for you, sir.
skills.
I can't show
Ah.
you because my laptop's still not working, so I'm having to use the iPad.
Ah, yes. All right, so it was James and Christina Prather were the respondents. He was ordered to show their accounts and they failed to appear. All right, so we'll issue a bench warrant then for James and Krista
Yeah.
Prather for failing to appear. The bench warrant amount will be $2,330. You got that, Michaela?
I did, Your Honor.
Okay. Thank you, sir.
I don't understand what I do next then.
You don't do anything. So there's a bench warrant for their arrest. If they get pulled over or if the police go out to look at their place, they could arrest them. And then the only way they could get out is if they pay $2,330.
Oh, okay.
Okay?
Okay. Do I need to leave any of the what the total amount is?
You take it over to Ms. Knitter over at the window, civil window.
Okay.
All right. Thank you. We're all set.
Thank you, sir.
All right. We are now on the case of Progressive Marathon versus Dylan Cisco, file 20-08111GC. Cisco, please unmute yourself and identify yourself for the record.
Dylan Cisco, the defendant.
Okay, is there a plaintiff here or an attorney representing the plaintiff? No. Let's see. Michaela, have you had any contact from any law firm regarding this case indicating that they're going to be late?
Your Honor, I apologize. I do have someone coming in right now.
Okay,
No, I did not, Your Honor.
okay.
Hi, Your Honor. I apologize for running late. I had a mediation that ran over by 30 minutes.
Okay, are you here for, please state your name for the record?
Yes, I am here for a Progressive Insurance Company.
Okay,
My
and
name is Tiffany Williams and my P number is 74809, and that's Progressive Marathon Insurance Company.
thank you. All right, today's the time and date then set for a motion for summary disposition. And Mr. Cisco, you're representing yourself, is that correct?
Yes.
Did you get a copy of the motion for summary disposition?
Yes, I did. It's sitting right in front of me.
Did you file an answer or response to a motion for summary disposition?
I don't think I did. I didn't really know what to do. I just thought I'd be coming into court and then we'd figure it out. I didn't think I had to
Okay.
file for anything.
Okay, so it's kind of like having a tooth go bad and having a big decay in it and thinking that you didn't have to go see the dentist.
Okay.
So what happened was the attorney for the plaintiffs, meaning the insurance company that sued you, said, Judge, we should win and here's why. And then you didn't tell me why they shouldn't win. And the court rules, because you're representing yourself, the court rules require you to file an answer and provide the information. So did you get a copy and did you read the Did you read the information?
I just got this yesterday, and I sent pictures of my truck to the Midland courthouse because I had to write down what happened on paper and then send in evidence is what they told me. So I took pictures of the back of my truck, and it wasn't like how it got hit on their photo, how they were saying. She drove her car completely up under my truck from the back, and it no slowing down. It was like 55 mile an hour. I went right up my seat and hit the roof and come back down. I got out of the truck and I had to park it in my buddy's driveway was why they thought it was how that happened. But I ran out to her car. I got her out of the car, made sure she was okay. But
So you're saying that, well, were you cited for
I got a failure to yield. Yeah, I'm sorry, Your Honor.
Go ahead.
I had a failure to yield ticket that they gave me. The female state police officer talked to me for less than 5 minutes, and she went over and talked with the girl and her family, and she was over there for 10-15 minutes and then come back with a ticket for me and then told me to go home. So I figured everything, was settled, but then I ended up getting sued about 6-8 months ago over that.
Okay. Let me take a look. This is.
Your Honor, in the civil information under the hearing exhibits, he had sent those pictures in for his, let's see here, I believe it was for his pre-trial last time, so I did get those in. It was under the court date.
Yeah, but they need to be linked to the case itself, because I'm not going to go look at probably in another folder for hearing exhibits, so they probably have to have some link if they're scanned in to the file, because I don't see in here in the file or where that's at anywhere. Does it? Are they in there?
Yeah, he had sent them in for his pre-trial. So it's in the civil information under the civil case, and it's under the 6.
No, so I'm talking about the link like we scan documents, like the exhibit list and that type of stuff. Is it in the GIS linked to it through Cherryland?
How this works? We don't really know either.
I'm guessing not. All right, so we have the motion for summary disposition. Let me pull that up.
I can't speak to the photographs because I'm looking at the file. I don't see those. But
yeah, you probably did send them, Mr. Cisco. You probably did not send a copy of the photographs to the attorney for the plaintiffs, did you? Just to the court?
Yeah, I didn't know how to get a hold of the attorney because there was a different one this time instead of John Barr, I think.
Jeffrey Beers, yes, he's on vacation this week.
I'm sorry.
No, that's okay. It's fine.
Right, so this is a subrogation claim, correct, Ms. Williams?
Yes, Your Honor, that is correct. And just for the record, that this is not necessarily on point of what we're discussing, but I just want to just put on the record. It looks like we served a copy of this motion on June 4th to the address that we have on record. And just to 2 points, and again, I know I'm getting a little bit in the weeds and maybe getting ahead of the court, but the police report did cite Mr. Cisco, but also there were 2 witnesses. I'm not sure if that's who he's referring to as the person's family, but there's 2 witnesses, Marvin Arkinwowski and Matthew Eden. And so that's probably why the officer did not spend much time talking to Mr. Cisco, because there were 2 witnesses to the accident.
Ah, okay.
And they weren't even there when the accident happened. They showed up like a half hour after everything.
Okay. So just take a look here through the facts. You just give me one moment to reread this.
Your Honor, we did send
Yes.
you an email with the pictures for your convenience.
Okay. Okay. Do you have a red truck, sir?
Yes, red F-150. It's a 1991.
Okay. This, you'd sent this in June. This,
Yeah, yeah. I didn't know what happened to it because it never got brought up last time. But
so you're saying that there's some facts in dispute. You're disputing the fact that you caused you were the cause of the accident.
yeah, because I backed out of that driveway, how they show it where I was parked in the driveway and she hit the side of my truck. I actually pulled fully out into the road and I was moving forward and there wasn't nobody behind me when I pulled out and I got rear-ended and her car went right up under my truck. And I don't get how you see a truck pull out in front of you, you try to stop or something or turn or anything, but I don't know.
Okay. Ms. Williams, I see you, the legal theory, and I know the attorney of record is on vacation, so I don't mean to catch you off guard. I'm certain you know it looks like a C9 and a C10.
That is correct. Yes, Your Honor. I'll speak more to the C10. Just based on his answer. I mean, I think he does it kind of advance that in his C9. I mean, excuse me, advance that in his answer. So I'll speak as far as the C10. Now he indicated on the record, and also in his answer too, that he was backing. There hasn't been any evidence to lead one to believe that Miss Little, the driver of my client's insured vehicle, there's nothing to lead us to believe that person was excessively speeding. So although he may have backed out of the driveway, he still had a duty to not be in that space until she passed by, because he has to yield the right of way. So the fact that he was there and then she hit him on the side does not negate her that he had to yield the right of way to her. And so that's why I presume that he was cited. He probably advanced that, and I understand what he's saying. He probably advanced that same information to the officer, and based on his admission, that would still put him more than 50% at fault for the accident, because he exited a private driveway. Whether he was backing or pulling forward, he still had to yield the right of way to oncoming traffic. The Miss Little had no duty to stop. There was no stop sign. There was no yield sign. It wouldn't be appropriate to say that she should stop in the middle of the roadway. He would have to have exited in enough time to get out of the driveway, set himself in the proper flow of traffic, the proper direction of traffic, in order for her to be at fault for then at what point will be a rear end accident. But that's not what happened. He was backing out. He was struck when he was backing out. He had not cleared the driveway, meaning that he had not backed out, turned his vehicle proper, and started to move forward in the flow of traffic. So as a result, he would be more than 50% at fault for not yielding the right of way to that oncoming traffic.
I also, Your Honor, the EMTs that showed up, they could see where my truck got hit, and it was definitely in front of the driveway because there was dirt inside of the fender wells where I got hit that fell down. And I was already moving forward. I wasn't going fast, but my truck's a manual, so I had to take time to shift it into gear. And I got into first and I started rolling and I just got hit. And it left dirt out into the road where I got hit, but I didn't take any pictures.
You were backing out of the driveway onto the road.
Yep.
And then getting it from reverse, because it's a manual shift, into first gear, and you weren't quite up to speed
Yes.
You weren't quite at the speed yet for the speed limit.
Yes, Your Honor. I was nowhere near the speed limit. I was probably doing around 5 miles an hour when I got hit. And I was headed east on Broomfield. And then my truck started making noises after I got hit, and I pulled into my buddy's driveway because I seen how bad her car was and there was smoke everywhere. I didn't want it to roll back onto her car. So I pulled it into my friend's driveway, and I got out and I got to her and opened the door and checked to see if she was okay. I got her out of the car, and her glasses hit her in the face, and she messed her hand up too. She said she hit it on the steering wheel.
So she was heading the same way you were?
Yes, Your Honor.
So she rear-ended you as you were backing out of the driveway and moving forward?
Yes.
Okay. Did you tell that to the police officer? Hang on, Ms. Williams. Did you tell that to the police officer?
I tried to, and then she left and never came back. I figured I'd talk to her again, but it never happened because I just figured, we'd talk a little more, but.
All right. I think I've heard enough of the information to make a determination. So I am going to grant the motion for summary disposition based upon C10. So the issue, Mr. Cisco, is that I believe what you're telling me is that you pulled out and you were heading forward. But the reason why the police officer, once you said that information, when a person comes onto a roadway,
yes,
people already on the roadway have the right of way traveling at the speed they're traveling. So they don't have to slow down. I mean, it'd be obviously they want to avoid a collision, but they don't have to slow down because you pulled out in front of them. So when you backed out, I believe that you were going forward, but if you're going 5 miles an hour, the speed limit's not 5 miles an hour. Someone behind you comes up too quickly. That's the reason why you got cited. And that's why the police officer probably didn't come back, because your story would have said you didn't allow enough time when you pulled out to get to full speed. So a person coming onto a roadway has to give right away to the other person who's already on the road. That's why they never came back, is because essentially you agreed with their side. They said you pulled out and they couldn't avoid the crash because your truck wasn't going forward fast enough. They're not saying you backed into her. What they're saying is you didn't look enough ahead to engage the speed, and then the crash, probably the person was still traveling at the speed. I'm guessing on Broomfield it's probably at least 50. I guess it's 55.
Yes,
right
it
there.
is.
So if someone's going 55 miles an hour, it's just really lucky that no one was injured more than what they're stated. So I believe you. You're telling me the truth, but the issue is the law works against you. So even if you had a defense, it wouldn't have been a valid defense because you don't have the right of way when you enter in the roadway of traffic. So I'm going to grant the motion for summary disposition rather than hearing it. I believe you're telling me the truth. So whether I put you under oath or not, I think you're telling me the truth, but you weren't right in the way that you backed into it. You clearly did not intend to smash into anybody. I get that. And typically when people think of it, if you were both in the road and you were both driving along and then you stopped to turn and she smashed into you, then she would have been at fault, because you have to pay attention to the people in front of you. But a person driving on a roadway at the speed limit, not above it, they have a right to not believe someone's going to get out in front of them and then not get up to speed fast enough. And I've driven a stick shift. It is hard to transfer from reverse to forward. So I don't think you did anything purposefully or that you meant to cause a crash, but you were wrong in how the traffic laws work. And so I'm going to grant them. Go ahead, sir.
I was going to tell you too, also, when you go on Broomfield, there's an overpass and it's headed straight uphill. So it was kind of hard for me to pick up speed.
Yeah, I would believe all of those things are true. But the way the laws are written is that once you get out there, you either have to have nobody behind you or you are at the right speed. So I'm going to rule against you, although I think that, it sounds like you were quick to act and took care of the person in the other car. And it sounds like you're a good humanitarian and that were kind and cared about another person. All of those things I believe are true as well. But you were wrong. And unfortunately, you didn't have insurance either. That's why this whole mess is kind of coming into place. You probably also got cited in, I guess, Isabella County is probably where the crash took place.
Isabella County, but I didn't get anything for no insurance. I thought I had insurance, but there was a 3-day lapse in it when I got hit in that accident.
Boy, it just sounds like a whole bad set of circumstances. But the good news is you weren't hurt. Good news is that it doesn't sound like the person driving their car was significantly hurt. And for that amount of money, which is a lot, but it's less than a college education, you learned a lifetime education on making sure your insurance doesn't lapse. And now you know the laws about getting out into traffic. So all's well as far as health. Everyone's healthy, everyone's safe. And Mr. Cisco, I do thank you for taking care of Miss Little to make sure that she was okay. I think that was an admirable thing to do, but I have to rule against you. So,
Okay.
Ms. Williams, do you have your judgment? I think you've already prepared it. It looks like there was one in the file. Would you prefer to do that, or would you like to fill in the documents and send it in?
No, Your Honor, can I present the one that was already submitted to the court earlier?
You can.
But it was also sent to the defendant as well.
Okay, then I will sign that order.
Okay,
Thank you
Your
very
Honor,
much. Michaela, what?
I did put it on the bench for you.
All right.